This is Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting. Today, I would not only be deliberating as a hedge fund manager, but I would also be deliberating as a law student. Guys, we need to understand that financial market is very big, and one human life is not sufficient to learn everything in the financial market. As we speak, almost every passing day, there are changes which are happening in the world of financial market. And some changes are so substantial that it takes even months to understand these changes. And if I speak in terms of legal parlance, then it takes months to have an interplay as far as these changes are concerned. So as we speak, the government of India is planning to have GST, which means goods and service tax, indirect taxation shortly, into an ambit of PMLA Act 2002, which means sooner or later, GST, goods and service tax, would be a part of Prevention of Money Laundering Act. As we speak, we have various provisions in India as far as the enforcement of financial markets is concerned. Securities and Exchange Board of India have many circulars in place. The right enforcement of these circulars are happening or not, that is a substantial question. On the contrary, Reserve Bank of India is having substantial circulars in place. Example, very recently in March 2023, Reserve Bank of India amended the Master Circular on Know Your Customer, KYC. And this is around 100 plus pages. So study 100 plus pages and try to see the difference between the earlier version with the current version is definitely a cumbersome exercise. But having said that, one thing which we really need to understand is that we have PMLA also, which is called Prevention of Money Laundering Act. And this act is nothing but a set of many rules, arbitration and stats. So let me show to you. This is called Prevention of Money Laundering Act in India. As you can see, the Prevention of Money Laundering Act in India. This is called the Depositor Acts 1996. Basically, depositories play a very important role in every financial market. We need to understand that. Because without depositories, and more importantly, without custodians, no financial market, especially the capital markets, can perform. So let it be very honest that until otherwise, there is a dedicated act of depositories and there is a dedicated act of custodians. No financial market in the world, no capital market in the world can survive. Majority of the financial scandals and offshore routing transactions are happening only because the depositors are not in sync as compared to the stat. Then we are having this Security and Exchange Board of India Act. In this, you have the SEBI Original Act 1992. You have the Custodian Acts, you have the Annual Report Act, you have the Settlement Act, and you have the various other acts. But having said that, these acts are not foolproof. Foolproof in the sense like the world has changed, completely changed. The way foreign portfolio investors are taking positions in India, this is completely different of what we envisaged earlier. The way the sub-accounts are performing, this has completely changed. More importantly, the way participatory notes are happening, this has completely changed. To conclude, the offshore banking is completely changing, but the acts are not changing. But having said that, there is definitely a bright light at the end of the tunnel. And that bright light is nothing but the Rule 9 of PMLA Act 2002. I don't know till what extent you are following the SEBI case as against Adani's. But having said that, very recently SEBI made a statement in their affidavit to Supreme Court of India regarding opaque structures. To be honest, I fail to understand the technical meaning of opaque structures because as a financial person, opaque structures is an English word to me. And I'm not saying whether it's a part of stat or it is not a part of stat, but having said that, one thing is clear that when it comes to foreign portfolio investors, which is shortly known as FPI, when it comes to AIF, which is alternate investment funds, whether it is category 1, category 2, or category 3, and you are expecting that there is no layering of FPI which has taken place, then I am really sorry because this presumption is not always correct. Foreign portfolio investors read with alternate investment funds, read with the private equity firms, read with the venture capitalist firm, are those financial institutions who love to operate from tax havens. And unfortunately speaking, we may have forums like Financial Action Task Force, we may have forums like Bank of International Statements, we may have few public forums who are tracking the information of foreign portfolio investors. But unfortunately speaking, the right layering of these foreign portfolio investors are next to impossible. The reason behind is that because it is a layering over layering over layering over layering. Example, if I speak about alternate investment funds in India, which is called AIF, it is divided into three parts. We have separate video about AIF like AIF category 1, AIF category 2, AIF category 3. And you know the beautiful reason? The beautiful reason of AIF is that none, whether category 1, category 2 or category 3 is allowed or rather is being pushed by the regulator to upload the portfolio in public. There are hundreds of alternate investment funds which are currently active in India. Even today, when I was doing my research on internet, I got to know one more alternate investment fund has been approved in India. But when the same alternate investment fund would take up a position in India, would take up a position which is on behalf of their principal. Now, in technical parlance, the principal means a person who commit the money in the AIF. So basically in alternate investment fund, a principal is a person who first commit the fund. Example, you go to India, you get the approval of alternate investment fund. And once you get the approval of alternate investment fund, then we are committing in writing, of course, as an agreement, no verbal commitments. We would be pumping 20 crores, 50 crores, whatever, as a money in your AIF. Based upon your category, which is AIF category 1, probably category 2 or category 3, you are allowed to invest either in listed securities or unlisted securities or probably both. This does raises our biggest contention to me. And that biggest contention is that in the countries like India, we all know how these unlisted securities are traded. Example, few months ago, internet is full of Byju's. Like Byju's will going to be a big tech company. One day it will be this, it would be that, and so on and so forth. The grey market in India was very active as far as the private purchase of Baiju stock is concerned. But today, as we are speaking this video, as we are making this video, we know what is happening with Baiju's. We know that Baiju's position has reached at a level when there is a confirmed financial crisis in the Baiju's. Thousands of people are asked to step down. 3 board members are stepped down. 3 who retained, they are the family members and the founder and the co-founder. We all know what is happening in Byju's. There is nothing which I am saying you are not aware about it. But few months ago, Byju's was proclaimed as one of the most valuable startup in India. Most valuable startup in India. There are hundreds of alternate investment funds who are registered in India. And many of the alternate investment funds are belong to Mauritius, which, by the way, is considered as a tax haven. We all understand the stories of Mauritius. There are ample of stories pertaining to Mauritius which are easily available on the Google. Henceforth, as we speak, which is around 14th July 2023, around 6 trillion plus, which is 6 lakh crore plus, is the alternate investment fund industry. And as per your category, which is either category 1, category 2, or category 3, you are allowed to invest either in listed securities, unlisted securities, or both. Henceforth, out of this 600,000 crores, I repeat, out of this 600,000 crores, how much of the funds is being invested in unlisted securities? This is something we are not aware about. Henceforth, the very important thing which links my earlier deliberations is the prevention of money laundering, which is section 11. Let me first study the section 11 for you. It's very important, which is power regarding summons, production of documents and evidence. The adjudicating authority shall, for the purpose of this act, have the same powers as are vested in a civil court under the Code of Civil Procedure, which in our parlance known as CPC. So actually civil cases are litigated like CPC, while the criminal cases are litigated under CRPC, which is criminal procedures. Having said that, we need to understand one thing very clearly, that both CPC, which is Civil Procedure Code, and CRPC, which is criminal procedure, they are procedural act. They are not substantive act, which means you can't penalize them. To penalize them, there is IPC, which is Indian Penal Code. But yes, CPC, read with CRPC, is a procedural. But having said that, they are divided into chapters, chapter 1, chapter 2, 3, like this. And CPC, we have orders also. Order 1, Order 2, Order 3, like this. However, we don't have these provisions in CRPC. So this is section 11, which is power regarding summons, production of documents and evidence. But very important thing which I always wish to read is the 11A, which is the verification of identity by reporting entity. Every reporting entity shall verify the identity of his clients, the beneficial owner, by point number A, which is authorization under Aadhaar Act, offline verification under Aadhaar Act, use of passport issued, any other officially valid document, and modes of identification. This 11A is very, very important. Then we have section 12. Every reporting entity shall maintain a record of all transactions, including information relating to the transactions covered under Clause B, in a manner as to enable it to reconstruct individual transactions. Furnished to the director. Director means the Director of Enforcement Directorate. Furnished to the director within such as may be prescribed information relating to such transaction, whether attempted or executed, the nature and the value which may be prescribed. And in this act, there is a concept of principal officer. Probably in this video, I'm not covering the principal officer. Maybe the next video I would be covering about the principal officer, but let me tell you one thing very upfrontly, that PMLA Act very apparently, very clearly and without having any ambiguity, I repeat, without having any ambiguity, explained the principal officer. More importantly, in 2015, there was a letter which was written by Ministry of Finance to all the exchanges like Bombay Stock Exchange, National Stock Exchange, Multi Commodity Exchange, NCDX and all, where they mentioned this PMLA rule number 9, which I would be speaking in my later videos when I would be linking this, and they linked the concept of principal officer very, very clearly. Rather, in one of the videos, they even linked this with FIU, which is Financial Intelligence Unit. Remember that India is a member of FATF, which is Financial Action Task Force. Ladies and gentlemen, this is Rahul Magan from Treasury Consulting Group. You knew my personal number, +91 9899 242 978. Let me repeat, +91 9899 242 978.